you want to go for arbitration. You the buyer, because you want to recover your money back. With arbitration you get your money fast. And then the seller said, no, we'll go to court. Knowing fully well that the time they're in court, you can use the money to keep transacting and making more interest. Meanwhile, you who has paid, you can't recover your money back. The person who will lose more is the buyer. That is why, as a buyer, maybe you should be the one to draft the contract of sale. If the seller is going to draft the contract of sale, get a lawyer that will review that contract of sale for your own peace, because your lawyer is going to back you to make sure you don't lose the deal. Hello, my smart investors. How are you guys doing again? In my last video, I said a story about a contract of sale that a client did not have, and that was what almost destroyed the deal. Number one, you're buying an off-plan property, or you're making part payments, or there is something that is making you not to make full payments. Don't forget, my name is Annette. I'm a legal practitioner, and I'm here to guide you to safeguard your investment. Like, share, subscribe, follow, and drop your comments, ask questions, and you can inbox me in case you need my assistance for anything. So one of the details, or one of the most important things you need in a contract of sale to make it legal, number one, the identity of the parties. Who is the seller? Who is the buyer? Even if it's a company that is buying, you also need to know the name of the company, although I will say something about buying under a company name in another of my video. Then description of the location of the property. You need to get the direct description, and that can be backed up by a survey plan, because without the survey plan you will not know the exact location. Or if it's because there's a property I dealt with, they gave me a survey plan with a particular square meter of property, and when I was like, okay, what is this? Like, how many, where is this? He said, we're so sorry, we're not able to go and do the survey whatsoever. And my client, I said, but okay, this might endanger your property. Well, at the end of the day, you need to give the main location, the main details of that property. Another thing is the purchase price. Purchase price is very important. How much is the price that you're buying that property? Then another thing is the payment terms. Even before the payment terms, how much have you paid? Or how much is the buyer paying? And how much is the balance? Instrumental payments, what are the terms? How many months is this payment going to be made? And what will happen if the payment is not made at the time the payment should be made? The dates of the transaction is very important. The dates that the money was paid in the account, the dates that the next money should come, what should happen if it doesn't keep to that promise or the promises to making those payments. Then the default clauses. If after I make this payment, if you sell the property before the agreed time, what should happen? If I promise to make this payment in so period and I don't make the payment, what should happen? And it doesn't stop there. If, for example, now they give 1 year to make the payment, what should happen? What is the next step to follow? That is my own secrets when drafting. Then you also need the dispute resolution procedure. If any of the parties breach, are they going to court or are they going to arbitration? If you go to court, it might delay. But if you go for arbitration, it may be faster. So you have to put that detail so that it not look like you want to go for arbitration. You the buyer, because you want to recover your money back. With arbitration, you get your money fast. And then the seller said, no, we'll go to court. Knowing fully well that the time they're in court, you can use the money to keep transacting and making more interest. Meanwhile, you who has paid, you can't recover your money back. So for me, if I have a client, or for all my clients who have come to me, I don't go to court. Court is very good. But when it comes to money like this, transaction like this, we'll go for arbitration so that you recover your money very fast. Then another thing is condition that must be fulfilled before completion. If, for example, is off-plan property, conditions like they will roof the place, or they will put tiles, they would have done, because there was a property I'm also dealing with. When I saw the drafting of the property, when the client was making instrumental payments, they agreed that they are going to make the property, they are going to build the property to a certain level, and that is where it's going to stop. And then the buyer who has started making payments will complete it from that level. So the buyer made a payment for the property, for the land itself, and for them to build that property from the foundation to the roofing, to fixing the windows, and then when it comes to the plastering, electricity, the tying of the floor, the plumbing work, the seller, the buyer will do as they will. They'll pick their own their own um, what I call it, their own ceiling, their own electrical stuff and stuff like that. But that was the agreement they made. But imagine they didn't make that agreement and they finished building to that extent. The buyer will say, like, wait, why are you doing half work? Who is going to do the electrical work? Who is going to do the plumbing work? So these are some reasons why you need to put details of what the contract of sale should look like. Then when it comes to instrumental payment, the details you are looking for is like, okay, I am making, it's a property of 100 million. Okay, I am paying 50 million right now. In 4 months' time, I'll make payment of the other 50 million. These are things that should be in the details. If I don't make the full payment, okay, you give me like 30 days or 14 days or stuff like that. These are things that should be detailed in your contract of sale. And these are the things that will save you from losing the money. The person who will lose more is the buyer. That is why, as a buyer, maybe you should be the one to draft the contract of sale. If the seller is going to draft the contract of sale, get a lawyer that will review that contract of sale for your own peace, because your lawyer is going to back you to make sure you don't lose the deal. It's more of the buyer that will lose because the buyer has paid. But where the seller will lose is where it makes the opportunity of him selling to other clients who are coming with bigger sales, who are coming with bigger money. For example, at the time he sold the property to you and was waiting for instrumental payment, he sold the property for 100 million. After he has sold the property to you and is waiting for the 6 months for you to make full payment, other people have come to make payment of 120. That is where the seller will lose it. But with a complete contract of sale, detailed contract of sale, both parties will be serious because they know with that detailed contract of sale, two of them will have a price to pay. Anyways, this is how far I can go. Let me see if I have more things here. Don't assume. Put everything in writing. Don't assume that, oh, I know he will make payments. We agree that he's going to make payments in 6 months. And maybe we pay this month and maybe he doesn't pay next month and the other month. Assumption is not okay. In real estate, words of mouth is not an agreement. You need an evidence to prove whatever you have to say concerning the property. Anyways, this is how far I can go. My name is Annette from Lexi Ann's Property. If you're thinking of buying real estate, don't forget to like. If you're thinking of buying real estate, you can reach out to me. If you need assistance, you can reach out to me. But for now, like, share, subscribe, follow, and drop your comments. I hope to see you in another of my. I hope to see you in another of my video. Bye for now.